numbers are starting to slow, so it looks like most people are in, so I'll start the event properly now. So welcome to today's event on emerging approaches to the regulation of biometrics. My name is Imogen Parker. I'm Associate Director for Policy at the Ada Lovelace Institute. For those of you that don't know us, we're a research and public deliberation institute based in the UK, and we have the remit to ensure that data and AI work for people and society. And biometrics, trying to make sure that biometrics works for people and society has really been something that has been preoccupying us right from our inception a few years ago. It's been a really key topic for us, and we're in the midst of quite a deep dive on the subject. We've really been focusing on two kind of types of evidence there. The first kind of angle we've been taking is trying to understand and amplify the voice of publics around this, really trying to understand what people see as proportionate use, how people would feel comfortable these sort of technologies are used and governed. So in September 2019, we published a public survey of public opinion looking at facial recognition, which revealed most people want some restrictions on use in the UK. That triggered a call for a voluntary moratorium to buy the space and time we need to really undertake genuine public discussion and work through how regulation needs to evolve. And across a lot of last year, most of 2020, we ran something called the Citizens Biometrics Council. And that was 60 members of the public, a really in-depth kind of citizens jury approach to bring public voice into the debate around technologies, to understand, really what people want to see in terms of governance. The other piece of work has been looking at the law around this, and we commissioned Matthew Ryder QC to undertake an independent legal review of the governance of biometric data in the UK. That's due to report really soon in the next month or two. So that was initially called for by the Science and Technology Committee, which identified the need for new potential legislation and really to better understand where laws are leaving gaps, are overlapping, and really understand where the kind of legal structures are at the moment and how they might need to evolve, both to keep pace with use now, but also to look forward to future uses and to be adaptable enough to keep track in the future. So I'm really excited by today's session, where we want to explore how different jurisdictions are approaching some of the issues posed by biometrics, understanding how they're even defining biometrics and how they're stepping up to this challenge of regulating a diverse and complex and evolving set of technologies. I'm really delighted to be joined by three really deep subject experts on this. We've got Brenda Leong, who is Senior Counsel and Director of AI and Ethics at the Future of Privacy Forum, to take us through the US case study there approaches, where we're seeing a real patchwork, I think, of state level regulation emerging, really focusing around some of the limited deployments of facial recognition technology. And that feels like where a lot of the debate is focusing around the world. We're joined by Amber Kack, who is Director of Global Policy and Programs at AI Now Institute, and give us a bit of an opportunity to get into the recent European Commission's proposals on regulation for AI, which had a large section really explicitly focused on the challenge of biometrics technologies. And we have Professor Fraser Sampson, who took up the newly created role of Commissioner for the Retention and Use of Biometric Material and the UK Surveillance Camera Commission. So that was bringing together two roles that were separate. So I think I can still say new Commissioner. I think you've been in post about 3 months, but we're kind of keeping that sense of novelty for as long as possible. And really just to shine a spotlight on what the state of play is in the UK at the moment, particularly in England and Wales. So thank you all firstly for joining us. I hugely appreciate you taking the time today. I wanted to just start the session by perhaps turning to Amber. Wondered, we've focused this explicitly on biometrics. Why do you think we should be focusing on biometrics when it comes to regulation? I wondered if you could just take us through a little bit around, what are we talking about firstly? What are some of the risks? What are some of the advantages before we get into that question of how we regulate biometric data and technologies?
Thanks so much, Imogen. So I guess like the first thing I'd say, and this is an increasingly popular refrain among civil society, which is that we regulate biometrics because the kind of continued linear growth and expansion of these systems is not a foregone conclusion. It's not inevitable, it's not organic, and it does need to be subject to greater democratic control. And this is important, I think, to say and say again, because the growing ubiquity of these systems has led already to a kind of a broadly uncritical acceptance or even a normalization of the fact that our bodily or our physiological data can and should be used to identify individuals across time, across context. And this, to your point on the benefits, this stems from like these assumptions that these systems are accurate, that they are beneficial, that they lead to greater efficiency, security, and safety. But today, I would argue that almost every single one of these assumptions is at least the subject of lively challenge, much of which has been led by a kind of global coalition of activists and researchers and investigative journalists, over the last decade that are really doing some deep, robust work on really assessing and evaluating these claims. And one way to summarize these challenges is, it's asking the question of who do these systems work for? And perhaps, even more importantly, who might they work against? So the claim that biometric surveillance, for example, makes communities safer is, it's heavily marketed, but it still remains loosely backed. On the other hand, we have seen that the risks of using biometric recognition and, particularly the incidence of errors are disproportionately being borne by historically marginalized groups, political dissenters, and so on. So, to come to your question of like, what are the justifications or risks that compel this conversation, I would say, we can simplify it to kind of at least three buckets. The first would be data privacy and security. And this will come out in our conversation, but that's because data protection frameworks, remain the primary vehicle of regulating biometrics globally. So this would include harms like collection of biometric data without consent, disclosure out of context, security breaches, and of course, and Fraser will talk to this, I'm sure, but there will be context-specific rules, for example, in the context of the criminal justice system and the specific rules of procedural fairness, in a criminal trial. The second bucket, I would say, is this emergent field of critique around accuracy, exclusion, and discrimination. So these are, harms that stem from inaccuracies, and that can be, false positives, it can be false negatives, and there are, many types of harms that come out of this. It could be exclusion as a result of, these errors, meaning that someone is unable to get access to a service. It could also be a false positive where someone is being, say, misidentified as a suspect. And again, we have mounting examples, particularly in the US, which I'm most familiar with those examples. And then the third, and this is, I would say, like, I would underscore it, which is, let's assume 100% accuracy. There can still be discriminatory uses when these tools are being used to disproportionately surveil or target particular groups, whether that's directly or that's indirectly. So that's the second group. And I think, like, finally, this is one of the justifications in the new draft EU rules, which is the kind of chilling effect on the exercise of the rights to free speech and movement in public spaces. And this is kind of particularly relevant for public or mass biometric recognition, for example, live facial recognition in public spaces or in the subway and that kind of thing. So yeah, I'll stop there with that summary.
Thanks, Amber. That's a really kind of fantastic set of challenges to just demonstrate what we're grappling with. I know that I mentioned a lot of the focus has been about facial recognition, live facial recognition. Just wondered if you could sketch out really in brief a few other types of biometrics that we really ought to have front of mind for this conversation, so it doesn't just naturally end up being a kind of facial recognition use.
Absolutely. No, absolutely. I mean, fingerprints have the longest history. Now, as you mentioned, facial recognition is the subject of the most lively debate, and that's particularly because of the ubiquity of faces on social media and the web, which makes, which has kind of led to the proliferation and a kind of unchecked proliferation of facial recognition tools. But to your question, I would say other bodily markers, kind of what's next, voice, iris or retina, again, have been around for a long time. Emerging areas of interest in this field include using behavioral biometrics, so gait, which is how a person walks, or keyboard and keystroke patterns, as well as what we call kind of multimodal combination of biometrics, which could be a combination of any of these that are then used together to claim, even more superior accuracy or uniqueness in the ability to identify an individual. And then finally, sort of the edge case, and I hope we have time to talk about that today, is the question, and it's an edge case, I would say, more from a legal perspective, which is, does emotion recognition count within the definition of biometrics? And this is a sort of vexed question, because emotion recognition, sort of by definition, is kind of relying on face or perhaps even voice data to infer kind of inner emotional states. It's not necessarily to identify me as Amba Kak as much as perhaps me as a woman from a particular demographic group, or the kind of emotions or I might be feeling at a particular time. And so to the extent that we insist that biometrics are should only be labeled as such when they identify you in terms of your demographic detail, I would say it's a kind of open question. But many recent moratorium bills in the US, for example, do define biometric systems to actually include emotion recognition as well.
Fantastic. Thank you so much. That's a really great opener for this event. And I'm very keen that we pick up that question of definitions and emotion recognition and other uses in this conversation. Now, just looking to, how different jurisdictions are tackling this, I wonder if we could turn to Brenda to give a bit of a overview, perhaps, of the state of play in the US and, where we're seeing emerging bits of regulation, bits of law in different states, whether there's any kind of federal approach to this. Perhaps if you just want to spend a few minutes laying out the landscape at the moment.
Sure, I'd be happy to. Thanks so much for inviting me to join today. I work at the Future Privacy Forum, which is a think tank in DC, and so we're focused on emerging technologies and uses. And my portfolio includes biometrics. So this is a really interesting conversation from my point of view in terms of comparing where things are going in a jurisdictional conversation, because as you know, in the US, we don't really have a comprehensive federal privacy law. We don't have a comprehensive biometrics law. And things, as you use the word patchwork, things get messy at the state level when things get regulated differently. And so it's sort of hard to keep up with, but at the same time, really interesting to see what kinds of things are being experimented with and done in different areas. There is movement at the federal level in the sense that in both the last 2 years and then again now, we are seeing bills proposed specifically to facial recognition. I think there's maybe even one specific to biometrics, but mostly the attention is really on facial recognition at the federal level. And they vary greatly. There's some that are proposing a moratorium on any federal use of facial recognition. I consider that really unlikely, but you never know what might happen. There's others that are more focused on putting together committees to review what is the federal government currently doing with facial recognition. Like, no, but there's not like a comprehensive place you can go and look and see where all the different agencies might be using facial recognition. Like, we know the FBI does, we know Homeland Security does, but we don't really know all of the places that do, or what databases they're all holding, or what access to other databases they might have. So it's very possible that we may see some sort of law at the federal level to at least sort of put structure behind what's actually being done or might be done, even if there's not a lot of limits or boundaries being set yet for how it should be done or could be done. That's definitely happening more at the state level, where there's a lot of activity. Over the last several years, there have been 3 and then 4 states that actually have established laws on specific to biometrics, not general privacy laws, but specific to biometrics. And that's Illinois, which I'll talk more about in a minute, Washington State, and Texas. And then over the last year or so, many more states have joined that. This last year alone, the 2021 session from January to April timeframe, which is the legislative session for many states, there were over 87 laws passed, or not passed, proposed, drafted, specific to biometrics. And only 7 have passed, but it just shows that there's a lot of interest and activity happening there. They cover a variety of things. Some of them are sort of AI laws that include very specific call outs for biometrics systems like facial recognition, which of course are based on AI systems. Some of them are specific to facial recognition. Most of them address government uses, especially law enforcement uses of facial recognition, but some of them are more general. Some of them address biometrics in schools. Some of them do address commercial issues. Some of them sort of, do the same thing that the federal level is doing, which is think about having a study to consider what is the appropriate approach to take. And we even do have some laws being passed at local levels, like municipal levels, at cities and that level. And in fact, Portland, Oregon was the first municipality of any kind, jurisdiction of any kind, to pass a law that restricted commercial private uses of facial recognition. So it remains to be seen. That's certainly going to be challenged, whether that is within the authority of theirs to do. So it's going to be really interesting to see how those kinds of things play out. In general, the issues that the states address are private rights of action, who can sue, who has to be harmed, who has standing to bring an action and under a law, government versus commercial uses, law enforcement, and what kinds of other limits might be applied. So most of the real activity at the state level in the US right now is under BIPA, which is the Illinois Biometric Information Privacy Act. And it's actually been around since 2008, but not really attracting a lot of attention or cases until the last several years, probably 4 to 5 years now. And there's a lot of case law being developed now. Not important to go into all of that at this point, but just to say that it's developing, it's not always consistent. A lot of states are looking to these cases and trying to figure out what to follow, and it's impacting many other areas of law as well. So a lot of the cases are employment based. That is, if an employer requires employees to clock in or out using a fingerprint or some other biometric, what are the rules and restrictions on that? What are the requirements around that? Remains very unclear. And just recently, like literally just this last week or so, there was a case that was resolved at the Illinois Supreme Court, which impacted the insurance industry, which is to say that when commercial operations have retail insurance, commercial insurance, and someone sues them under BIPA for a collection of biometrics, does the insurance company have to defend them in court? So it's kind of a wonky, lawyer kind of thing, but it's actually really important because it's going to play into who's supporting these laws and what their impact is going to be. And the court said, yes, the insurance company does have the duty. This does fall within the purview of what's being covered by that insurance policy, and they do have to provide a defense for the company. And then there were some other pretty interesting, but again, in a sort of in the weeds way, things about that case, about what that might set for precedent. I think one of the things along the lines of what Emma was saying is where we're seeing it move now, though. So that's all facial recognition and biometrics where we've been. I think that we're going to see voice recognition following in the steps of facial recognition. It has many of the same concerns about the ability to collect it passively, about the ability to collect it publicly. It's no harder to hide a microphone than it is a camera, or not hide it, but like have it be unobtrusive or not easily recognized. And it has the same sort of, ubiquity, like we're used to using screens. So we know our faces is interacting with the things we're doing. Now we're starting to use our voices with personal assistants in our cars, in our homes, with our handheld devices. Voice is becoming more and more of a user interface for those kinds of things. And like facial recognition, it has both personalized and non-identifying modes. So just because something's voice activated doesn't mean it's collecting and profiling you by your voice, but it could be. It could be collecting a voice print. And we are actually starting to see these cases being brought under BIPA. BIPA does include voice print in its definition of biometric. And there is currently a case with McDonald's who has been using or wants to use and has, I think, rolled out in a couple of test locations, voice recognition when you pull up to the drive-thru and you order your food. they want to collect and use that as a tag for repeat customers so that they know what your usual order is, or they can ask you if you want this, or, you know, all the things that businesses want to do in terms of understanding their customers' behaviors and trends and wants. And so they are interested in doing that with voice. And so there's been a suit brought under BIPA for that. And we're just going to see more and more of that. So in the same way that your face, many people's faces are in many places on the internet, your voice is too. So TikTok has recently updated its privacy policy for US members to say that it wants to collect biometric identifiers, including voice prints. And so as people use the functionality of services like TikTok or Reels, or I don't even remember the names of all the video things on all the different social media platforms, but as people go to that more and more, in addition to posting photos, they're posting live speech. That's going to become more and more of an issue, and we're going to see that taken up. So I know other people are going to talk about the EU, but the EU Data Protection Board did just this March release guidelines on virtual voice assistants for the most common use cases, which are the same here in the EU as anywhere else, which is, you know, interaction, executing the requests that you want the device to do, improving machine learning, biometric identification, and then profiling for advertising or content. So I think we're going to see that influencing both US laws and probably other places around the world as we start to recognize the challenges of voice recognition.
Thank you so much. That's a really perfect segue onto Amber to talk about Europe, but just a really great introduction, I think, teasing out some of these questions about, is it about the data, or is it about the use? What are some of the potential harms? How does biometrics, need regulating in and of itself, or is this part of data privacy? Is this part of employment law? How does this touch with other bits of legislative regimes and requirements? So really, yeah, thank you so much. That was a kind of great unpacking of some of those issues. Now, Amber, I wonder if you can just take us through the European Commission's proposed AI regulations. Got this really prominent section on biometrics that's been front and center. And perhaps if you could, both unpack it a bit for people that aren't really deep in the weeds, but also be great to hear your thoughts on whether it steps up to the challenge of biometrics, what it brings to the table.
Cool, thank you, Imogen. If I may, just because as with anything in the term, with the term AI in it, there's a lot of buzz on the new EU AI draft rules, and we'll get to that. But I think it's worth emphasizing that, there are current regulations for biometrics, like I said, in the GDPR, which have had their own track record with implementation. And so I think it's important to also remind ourselves of what those lessons are as we kind of move forward to the next phase of regulation. So to start with, I would say that both the GDPR and the kind of law enforcement police, data protection police directive that applies to law enforcement agencies, they do treat biometric data as more sensitive, and they do regulate in different ways for stricter requirements throughout the life cycle of biometric data. So collection, processing, storage, retention. And in fact, in the GDPR, if you read it, it actually reads as a prohibition on processing biometric data, but the devil is sort of in the exceptions, which remain vague. And so those include substantial public interest, and there are several others, including explicit consent. So in theory, the rule is that you should only collect face, if I can simplify, it is that you are only meant to collect face biometric data or other forms of biometric data when strictly necessary, and it's supposed to function to severely limit use. And yet, in practice, over the last few years, we've seen a kind of proliferation of these systems, including in circumstances where it seems evident that it was not necessary, and there could have been less privacy invasive means to do the same thing. So then the question is kind of like, why? And in our Regulating Biometrics report, several of our authors actually explore this, and they say that this kind of elusive evidence-based scrutiny of the proportionality between the means and the ends usually ends up in favor of a very kind of broad and nebulous rationale of public security, efficiency in service delivery. And for some reason, it has almost always served to enable rather than restrict the use of biometric systems. And legislation has also often been introduced after these systems are developed. And, with biometric ID systems, this is not specific to Europe, but globally, we've seen that, the regulation is coming too little, too late. And then there's a lot of path dependency and a reluctance to go back on these systems. And then EDRI actually noticed in their 2020 report that perhaps this kind of uneven application of biometric prohibition can also be attributed to inadequately resourced and in some ways kind of politically disempowered data protection authorities. And why I want to start with this is that these problems don't disappear now when we're starting to talk about the AI rules and even more regulatory agencies. But to summarize what the draft rules say, the first thing to note is that they create a kind of tiered risk system, right, of unacceptable risk users, high risk users, and very low kind of risk users. And the one that they isolate as being unacceptable risk is live, or it's a bit of a mouthful. So it's real-time and remote biometric identification. So that's biometric identification that can be passive from a distance, is happening. The kind of identification process is happening in real time, typically that have been used by law enforcement agencies in publicly accessible spaces. And here too, there are carve-outs. So if you can, and those carve-outs have themselves been critiqued by civil society. So if the law enforcement agency can demonstrate grave public threat, and then there's some very kind of helpful procedural friction in terms of police agencies also need to get prior authorization if they do end up using it by either a judicial authority or a kind of independent administrative authority. So this is, I would say, like a healthy degree of due process. It's a lot of friction, but I want to go back to where we started, which is, what are these various concerns we have with biometric regulation, with biometric recognition systems? And it does feel then that these rules are sort of artificially narrowing our attention to a small part of the pie, an important part, an egregious part, but still a small part of the pie. So even if we accept the notion that this is the most egregious use, I'm worried personally that any kind of rigid hierarchy of harms between the worst and the rest, especially at this kind of very crucial moment of enhanced public debate on, should these systems exist and where should they and whether, I worry that it could either lead to a free pass to a lot of worrying users, or potentially kind of delayed scrutiny, again, which at a moment when the kind of appetite for regulation and more bold regulation is the greatest. So I'll take one kind of controversial example because it's the pet one, which is, if remote untargeted surveillance is the worst case scenario, live facial recognition in public spaces, then the best case, or the most, what should I say, benign use is biometric one-on-one verification. And the example that's always given is like you use your biometrics or your face to open your phone, and that's obviously fine. But there's a lot of kind of assumptions associated with that. The idea that if you are willing to present yourself or present your biometrics in a cooperative way, frontal face with eyes open, then that is equated to consent or voluntariness. And therefore, it's also equated with higher degrees of accuracy because there's less chance of errors if you're, frontal face, eyes open. But again, here, these assumptions are falling apart, right? One, on accuracy, even biometric verification systems are still predictive. They're not immune to errors and biases across the lines of race, gender, and other demographic traits. And to Brenda's point, this is true also for voice recognition systems. And most importantly, I think like this idea that if participation is done with volition or knowledge, that individuals have real choice is kind of deeply problematic. So I keep going, and this is borne out by, welfare delivery systems where people really have no choice between either they get access to essential foods or, essential, services, or they basically don't really have any real meaningful choice. So I do think that if we think of the EU as setting a sort of global precedent on biometric regulation, as I think we should, given the precedent set by the GDPR, then this kind of rigid or even this like overly permissive notion of the worst and the rest I think can lead to a lot of these more concerning uses and particular harms being either unaddressed or under explored in the debate.
Thank you. That's really fascinating, and I think such a key point around the uses that go beyond the small piece of the pie and what's the rest of the pie, who's looking at the rest of the pie, and how does this work in practice. Now, let me turn to Fraser to talk a little bit about the state of play over here in the UK or in England and Wales. Perhaps you can just clarify as well that relationship with the new Scottish Biometrics Commissioner for people that aren't based in the UK. Yours is a new role. It's bringing together two previous commissioner roles, and it'd be great to hear a little bit about the thinking of your office and kind of where you see these debates, how you reflect on what's happening in Europe and the US, and what you see playing out in the UK as well.
Sure. Thank you very much, Imogen. Thank you very much for the Institute for inviting me along to take part in what is really obvious just from the last discussion, an area that is A, fast moving, and B, of great significance, not just to the lawyers and the technicians, some of us, but also principally to citizens, and I don't see that diminishing anytime soon, which I think is almost one of the first hurdles that you need to get over if you're involved in trying to regulate or even deliver public services. It's getting that discussion going and having a proper informed debate and leaving enough time for it to be had. So I think that as a starting point, that is really encouraging. In terms of the role here, and my role, yes, I'll deal with the jurisdictional point even within one particular state, which is the UK. My appointment is the coordinating rather than combining of two distinct statutory roles. One is a UK-wide role, which is for the Biometrics Commissioner, and the other is an England and Wales-wide role, which is for that of the Surveillance Camera Commissioner. And of course, AFR, which has dominated literally every conversation and email since I arrived in March, is one area where they allied already. I know that the dual appointment from the government was particularly to reflect this direction of travel. And I think at some stage before too long, we'll probably wonder how they were ever kept apart. But at the moment, they remain legally distinct. And so I have two hats, but only one pair of shoes. In terms of the UK biometrics functions, the Commissioner role covers retention and use of established biometric material. So for these purposes, that is data from fingerprints and DNA. Although again, it's very interesting given the breadth of the discussion we've just had, that at the moment we currently have footwear, which is clothing, regulated by a primary piece of legislation. And yet at the same time, most of the things that have been spoken of so far today are almost heading from biometrics into zoometrics. These are measures of life itself and people's lifestyle. So we do have some anachronisms in our current regulatory standards and framework. In terms of the Surveillance Camera Commissioner role, this is very clearly England and Wales wide, and is focused on the design and deployment and use of surveillance camera systems where they surveil public space. Again, there's been lots of discussions about what fits into those definitions and whether they ought to be changed in the future. And I can come on to some of that in a moment in terms of the overall standards. But I think it's also important to note that the other areas of regulation and standards within this field. So for England and Wales, we now have a new forensic science regulator under the 2021 legislation. So that is straight off the blocks. Gary Pugh was only appointed a matter of weeks ago. But very interestingly, the forensic science regulator enjoys a very wide scope for setting standards and a regulatory regime where scientific methods are being used in the investigation and detection of crime and the building of cases which will be used in criminal trials. I mean, that's not an entirely complete definition, but as a working definition, it'll probably do. And that's really interesting, I think, in terms of a slight change, because the emphasis there is about what it's going to be used for, because of course the use cases are absolutely critical to setting some areas such as proportionality. But I also think from the conversation that we've just had, it's the consequence. There is the consequence of being unable to open your own phone because it doesn't recognize you is entirely different from the consequence of a surveillance camera commissioner picking you up in public space and reporting you to some authority on the basis that it is presumed you've committed some criminal offense. They're entirely different. So the tech may be the same, but I think the consequences and the use are equally important. In terms of the approach in Scotland, there is a new Scottish Biometrics Commissioner, Dr. Brian Plastow. I've met with and discussed a number of things with Brian so far. He enjoys a similarly descriptive definition of biometrics and his own range of cover. And again, that is designed in a way to, so far as is practicable, take account of future developments and directions and the institution of maintenance and audit of standards. So I think between us, we form a significant part of what the Ada Lovelace Institute has called layered co-governance. I've met with each of my colleagues briefly, but plan to again shortly. And actually what we're keen to do is to understand how we can, between us, ensure that the advances in technology are matched by a correlative increase in accountability, legitimacy, and trust. So I think in terms of, only for my own office, I of course don't speak for the regulator or for Scotland and the Biometrics Commissioner. My approach to this has been to look at this from three perspectives in a sort of triptych of developments in what is technically possible versus what is legally permissible and increasingly what is societally acceptable. And I think a lot of attention and focus historically has gone on the first two, particularly in the second one of legal permissibility. But I'm increasingly finding evidence that irrespective of those two, the societal acceptability is where the future of this is already being shaped. So people are saying, we know it can be done technically, and we know that you might find ways in which under a particular circumstance, you could get it past the judge, but we still don't want you using it. So I think that's the area where a great deal of focus needs to go. And that's the area where I think events such as this are going to be particularly helpful. In looking at how the standards and regulation in this area can create a situation whereby the police are enabled to use all the tools and techniques reasonably available to them to protect citizens, prevent crime and disorder, and bring offenders to justice in an accountable, proportionate way that is expected of them in a mature and tolerant democracy. That's kind of my overall starting point in trying to understand where this development and where the discussion ought properly to go. Clearly, I don't set policy. I'm not responsible for policy. I'm an independent office holder, but I try where I can, albeit Imogen, as you said, fairly recently to the role, to guide and assist in that development. For me, I think that this area is not so much about specific technological applications. What is new now won't be for long. I think it's really important that people are able to have confidence in the whole ecosystem that uses surveillance and biometrics now and in the future. And I think that's where the standards and regulation come in. So it is unarguable that there are many examples of police surveillance systems that have been roundly discredited. And it's probably true that their use has eroded public trust, perhaps because they weren't sufficiently validated in advance, perhaps because they jumped the gun, and almost certainly because they weren't properly explained, consulted upon, and deployed under clearly defined policies. And these, I think, are principally matters of accountability against professional standards and regulation, rather than technical novelty, which I think has driven some of the consideration and reporting on them. I've spent a lot of time already focusing on drones, doorbells, and body-worn devices. And just by way of an example of how where some of our regulation and legal mandation meets, there is a list of relevant authorities who must have regard to the statutory code on surveillance cameras, which is published by the Home Office and overseen by my office. That covers police forces and local authorities, but probably numerically the vast majority of users of surveillance camera systems and CCTV have no legal obligation to have regard to that code of practice. But increasingly they are electing to do so, which I think is really interesting. So you can have a continuum which might run from begrudging mandated compliance at one end for some public bodies to the other end, where you have a sort of quality management approach and corporate social responsibility approach from large organizations and industry, saying this is the right thing to do because it deals with a lot of the concerns that people may have about training of users, about access, about retention and storage, and all those kind of things are addressed in the code. And there's almost an added layer of sincerity if I don't have to have regard to that code, but I've chosen to do so. And I'm working really hard with the office to encourage further organizations to adopt those standards voluntarily. So Imogen, I'll stop there for a second.
That's brilliant. Thanks so much, Fraser. That's really, I think, useful to hear slightly different approaches around kind of regulating and building trust and in these systems. There's been a few really interesting questions that have come in on the Q&A that I want to pick up, and actually the most recent one follows on really nicely from what you were just saying, Fraser. So Charles asked, between social acceptability and legal permissibility, there's also ethical acceptability, and wanted to solicit panelists' view on, I guess, that question of ethics and practical ethics, and whether or not those are tools we ought to be looking at in the governance regime. If anybody else wants to submit questions, do so. I've got like a whole long list of things I would love to ask, but put in questions on the chat and I'll follow up with the panelists.
So would you like me to pick up on that first?
Yeah, do. Yeah, sorry, I should have said, so, if anyone wants to just jump in.
Yes, completely. And one of the things that that I attended yesterday was the National Biometric Forensics Ethics Group, which is an independent group of experts set up by the Home Office with the very specific mandate to look at exactly that question, because of course, yes, there are areas of ethical use that kind of cross probably all three of those parts in that triptych, and they will and probably should be identified and agreed upon well in advance, as they are in other areas of sort of research and technology, and can exist there as a kind of touchstone in design and deployment, but then need to be constantly ongoing as we learn more about what we can do. So some of the things that group will look at will be the use of and is the use of familial DNA for genealogy in terms of tracing missing people, for example, and its reliability. So there will be a police input into that. There is an element of police activity in there, but it is not about law enforcement. It's a different setting, and the increased ability and capability that application could give is quite obvious. But how, where it should do it, and who should be accountable for it, and where the boundaries are around that is something that is pointed towards that particular group of experts who are not connected with any of the organisations that may well be conflicted in the view.
If I could just add on that question generally, I think it's a great question, and obviously ethics and AI is a whole topic at many places and in many institutions, but they're not separate. The social acceptability, the ethical consideration, and the legal compliance theoretically are all tied to the same set of values. The social acceptability, I think, is where we're seeing like individual cities taking the step to ban a specific technology, which is not really that common, even with many other controversial technologies or environmental programs or whatever. But their, emotional response, which is tied to their ethical values and beliefs, is so strong in this case. We're seeing this pop up within the legal system at a level that doesn't always happen, and in a very sort of inconsistent way, because different places have different balances they're willing to accept between convenience and risk, or however you want to frame those. And I think that's part of what the problem is, or the challenge is right now, is that there isn't consensus on what the ethical use of those is. There might be certain use cases that are mostly consensus, not okay, public real-time live surveillance tracking. And then there might be things that most people think are okay. And then where to draw the line in the middle is the trouble. And so that's, I think, what we're seeing with all of these different responses of guidelines and principles and local laws and federal discussions, or EU discussions or whatever, reflects the fact that it's not easy to say it's easy to say it's an ethical question. It's not easy to say what's the ethical answer to when and where and how to use these, because there are valid points to many of the perspectives within that gray area in the center. So absolutely, ethics is and should be part of the discussion. But I think saying that doesn't necessarily make it any easier to solve.
Absolutely, thanks. There's a question from Marion which looks at AI polygraphs. So the draft EU AI regulation aims to regulate AU polygraphs, emotion AI, which could result in more regulation of AI than of standard polygraphs. With the increase of this in the criminal justice system, what additional controls or regulation do you think is needed in terms of polygraph? I'd love to get your reflections on that, but also perhaps use that as a stepping stone to open up some discussion into the question of emotion recognition or emotion AI. Some of these, as you said at the start, Amber, some of these use cases that are kind of challenging our definitions of biometrics, or kind of knocking on the door of where we might need future approaches for regulation. I don't know if anybody wants to kick us off on emotion.
I'm happy to. I know Amber has thoughts on this too, but it's an area that we're working on a lot in terms of, like you said, the definitional boundaries. It's not necessarily and frequently separate. It's certainly a different technology to talk about facial analysis, which includes emotion recognition. The science behind emotion recognition is very sketchy, in my opinion. The science behind emotion studies generally, regardless of technological evaluation of them, is very uncertain. This idea that there are universal emotions that are universally expressed in consistent ways is very unproven. And so the idea that you can then take something that uncertain and apply technology to it and expect it to be any more accurate or reliable is very concerning, in my opinion. And so there are things that can be done in an analysis sort of way, both facial analysis or voice analysis, or some of these other things that people are finding in terms of like medical evaluations that do have some consistent relationship to certain medical conditions or things like that. But that's different than saying because somebody's standing there and I evaluate the way their face looks, that I can decide that they're unhappy or that they're happy or that they're engaged or that they're studying or that they're paying attention to their job or that they're going to be an employee that would fit into my company. And those are the use cases that we're seeing for this, which are just very concerning, in my opinion, because of the unreliability of this technology. And I think that that's starting to get a lot more attention because it's not even necessarily tied to identifying someone, which is we've spent the whole morning talk about is its own set of concerns in terms of privacy and liberty and things like that. But now this use case of, I know who you are, you know who I am, we're sitting there together or we're engaged in some sort of interchange, but I'm evaluating you in this way and using that information, and you may or may not know it, and it may or may not be actually fair and accurate information. So I'll stop there because I know other people have thoughts.
No, I think Brenda, you just set that up really well, because I think it's a good moment to underscore that even as we are having a robust conversation about how this technology has kind of mostly discredited scientific foundations, where at the same time, emotion AI is being used in hiring tools to gauge whether someone is so-called confident or nervous in an interview, and that is determining whether they get jobs or at least factoring into that decision. So the concern right now is that even as we're having a conversation about the untested nature of these technologies and the potential harms of these technologies, they're also being rolled out in the same breath. So I think one lesson here for the broader regulatory conversation is that sometimes conversations about procedural safeguards, like, what might be the transparency requirements that we put in place to tell people when their emotion AI is being applied to their face or their voice, rather than get to that question, I think we need to, I worry that it will undercut the more existential or more foundational question of should these systems exist at all. So I think we're at this kind of tug of, push and pull in this conversation where, it is important to put in place procedural safeguards at the earliest since these systems are in use, but at the same time, we don't want to undercut demands for much more radical prohibitions on some forms of these technologies that have proven harms, or more importantly, whether or not they have proven harms, they have kind of unproven benefits.
And I think that takes you back to your earlier point around the accuracy of these as well, that some of this stuff is just being optimistically used, perhaps. So there's different layers that we need to challenge this against, or stress test this against. I know we're getting close to the end. It's a question that's come in about biometric information being integrated into vaccine passports. And I just wondered, again, kind of slightly expanding that question, whether you've seen kind of worrying new developments, positive new developments, or at least kind of an expansion of biometric technologies in response to the pandemic in the jurisdictions that you've been looking at, whether that started to present new use cases, new challenges, or areas of concern. I wonder if anyone's got any thoughts on that.
I can give one example from India. I mean, it wasn't actually finally rolled out, but there was a comment made by a senior government official that perhaps facial recognition and Aadhaar, which is the digital ID system, might be used in the context of distributing vaccines, and would be made a kind of essential requirement. And so again, I think the assumption there is of uniqueness, of accuracy, of stability, and in a country particularly where these technologies have been untested, but also where there might be kind of connectivity, technological barriers, particularly for the elderly or those in rural areas. I think it just raises concerns of when we tie essential social services to technologies, such as biometrics that pose accuracy issues, that pose risks of exclusion. It feels like Ada Lovelace, I think, has been at the forefront of this. It needs kind of robust public debate, and all of these assumptions of efficiency need to be challenged. And I think in the same breath, we should be asking who is pushing the agenda of using these systems uncritically, and if it is coming from industry, I think those intentions, those motivations also need to be they need to be contested.
Yeah, I agree. This is, more than just vaccine passports, although obviously that's a prime use case at the moment, but this all ties to the whole concept of digital identity, with one of the components of that being a biometric identifier or multiple biometric identifiers. And we've had a couple of states in the US that used a biometric digital identity system for the delivery of the federal payments to people because of the pandemic, the unemployment benefits and the individual payments. And there have been documented problems, partly just because of the overall bureaucracy, not just the accuracy of the technology, but also because if the technology gives a false negative, it takes the person so long to challenge that and prove that and get it corrected and then access their benefits. And this is, this is access to the money that they need to buy food and pay their rent and, live. So it all kind of combines together. And the digital identity systems being developed around the world right now do tend to have a biometric component, and that's not necessarily a bad thing, but it is part of the concern about how to build these up responsibly and reliably. And as Amba said, in India with the biometric system they have with people's fingerprints, a lot of the problems we've been able to see at scale because they've done this at scale for 1 billion people. And it's highlighted what some of the challenges are going to be to try to make this work effectively for people, especially the people who are the most vulnerable and at the margins and most going to suffer if it doesn't work well.
Thank you so much. I feel like we've barely scratched the surface. We've got loads more really rich questions, but we're starting to run short of time. So perhaps if we could just, I just want to give you each an opportunity for a closing remark, perhaps around, if you were king or queen for a day, or, where you would prioritize how regulation needs to evolve, what needs to be front and center, what needs to be thought about by different jurisdictions to ensure that biometric data is used, biometric technologies are used in such a way that they minimize the risks, maximize the harms, work for people and society. Perhaps Fraser, if we start with you.
Thank you, sure. And briefly, I deliberately abstained from the discussion on such things as passports and so forth. My jurisdiction may be broad, but it isn't that broad, and I don't need reminding of it. So yeah, very briefly for me, within a policing, again, I emphasize policing, this is not just law enforcement, and that's more than just labeling here. Within a policing environment, the default position for our police in the UK remains that they generally enjoy public trust, and it's theirs to lose. So I think where we're looking at the regulation, the who says this works, the why, how do we know this isn't a solution looking for a problem just because we can do it? That's the focus. That needs to be the focus, as they don't lose that public trust that we already enjoy, because that is not a position that necessarily every jurisdiction enjoys. And we should treat it like the very valuable asset that it is.
Fantastic, thank you. Brenda.
I think I would just say that I think somebody talked about earlier the getting too focused on one particular concern and sort of sometimes failing to see the bigger picture and the additional implications. Is as much time as we've spent talking about these specific technologies, the concerns around them are all because of their impact on our underlying values and our underlying rights and freedoms. And I know that in many of my conversations, sometimes it's important to remember to take that step back and say, even if we fix facial recognition or stop using it or stop emotion detection, that doesn't answer all of our problems. And all of this occurs in a bigger technological soup than that. And I can track your location with your phone absolutely as easy, maybe easier than I can with facial recognition technology, and collect all the same kinds of minutia data about your habits and your travel and your buying and your family's activities and everything else. So let's not lose sight of the fact that these things are under attack by many technologies or the combination of technologies, even as we're focusing on the specific challenges of these. It always still needs to be in that context.
Brilliant, thank you. And I feel like the mess of technology soup is like an image that I'm going to definitely keep referring to, keep thinking about. Amber.
Yeah, I also love that, Brenda, but I would say let's go back to what already exists, a more rigorous implementation of the standards of necessity and proportionality that do exist in data protection law, and just a more evidence-based analysis of the link between means and ends, and that this analysis needs to happen ex ante as far as possible and not ex post. And finally, that regulation is critical, but weak regulation at this point will be an opportunity lost. So I do think that we need to be wary of weak regulation undercutting the potential for broad-based reforms, and really take the time in different jurisdictions to get it right and to have that robust public debate.
Fantastic. Finishing on robust public debate is a very Ada point to end it on. I want to thank all of our speakers for taking the time, and also participants for taking the time to spend with us this lunchtime or morning or evening, wherever you are around the world. We will be, as I said, we'll put this recording up on our site. We'll do a little transcript of it as well. So there were so many rich points there that it's great to tease out and drill into. We should have the next major output from Ada on this will be looking at this legal analysis, which might be coming in the next month or two. And in the meanwhile, we'll have further blogs and events on our site, so do check back in. But otherwise, thank you all so much. Have a great afternoon, rest of day, evening, and take care.
Thanks so much.